Hi friends, today I want to discuss 6 main types of family visas in the United States, including cases where you can do self-petitions, file for yourself without your relative sponsoring you, and we will also discuss waivers for when you enter the United States with like a weird situation or no visa or using somebody else's papers. So let's get right into it. My name is Marina Shepelsky. I'm an immigration lawyer for over 23 years, and today we'll discuss family visas that lead to green cards in the US. Before I start, subscribe and hit a like once you listen to the end and you enjoy this content. And also please share this video with your friends and family because sharing is caring. Let's get right into it. So number one visa type that you can file through family is immediate relative visas. Those are given to parents of U.S. citizens. So the petitioner is a U.S. citizen child over 21. Also, they're given to spouses of U.S. citizens and also to kids under 21 of U.S. citizens. There's no cap, so there's no line of waiting for these visas, but there is a brief processing time, and today we consider brief for adjustment of status about 1.5 years, and around 1 year and 8 months to 2 years for people who are doing consular processing for this. If you're in US, you're doing adjustments of status, and this category forgives any unlawful overstay of a visa. But what if you entered with no visa? Then you might be eligible for either I-601A waiver, a hardship waiver, where you have to show that your U.S. citizen relative would experience a really bad, extreme hardship beyond the usual unhappiness of being without a family member. So they can't survive without you in the U.S., and you have to show this through medical documentation, to show this through maybe a psychologist letter or other documents showing the special circumstances that the U.S. citizen petitioner would have to suffer through if you were deported to your home country as the beneficiary of this immediate relative visa and the beneficiary of the I-601 waiver. Sometimes it could be a waiver for a crime, a minor crime you might have committed, or untruths or lies or misrepresentation you had included in your papers. Moving on, the second type is family preference visas. They go by the letter in the law that identifies these, and usually the categories are F1, that's the child over 21 of U.S. citizen, F2A, spouse and children of green card holders, F2B, adult children of green card holders who are single, F3, which is married children of U.S. citizens, and F4, siblings of U.S. citizens. These, a lot of times, we process for consular processing, but if you are in U.S., you might be eligible for a visa if you're here in status, like a TPS with no overstay, or on a student visa or a work visa. There are waivers available in certain categories and in certain situations, again, based on hardship to the U.S. citizen or green card holder petitioner. Then the third category is the Fiancé visa, the K1 visa, for when the U.S. citizen, it can only be filed by U.S. citizens. They're engaged to an immigrant overseas and they want to get married within 90 days upon their girlfriend or boyfriend's entry into the United States. The next category is VAWA. So that's when you were married or you thought you were married. There was a ceremony to a U.S. citizen or green card holder, or when it's a parent of an abusive U.S. citizen child over 21 years of age. The next is special immigrant juvenile status. That is when there's a child in U.S. under 21 and you can get a family court order to show that the person has no parents in US or just one parent, or maybe even two parents, but they're not being supportive, they're not providing support and care for this child. And in that case, the child is kind of like an orphan of the court. The guardian is appointed, and the court says, hey, you should give this child a visa. And that's when we file, after getting the family court order, for the immigrant visa for this child. And there's a waiting line for this of approximately 5 years. And they do get deferred action when they get filed for SIJS and approved for SIJS. So once you're approved, you get the deferred status, meaning you're not going to be deported. But to get the actual green card or visa, you have to wait 5 more years. And finally, this is the I-130 petition for alien relative, the foundational petition that sets up immigrant visas. Immigrant meaning you're going to immigrate permanently to United States versus non-immigrant, where people are not immigrating to the United States, they're coming temporarily. So immigration law has set up those two main areas of visas as immigrant visas that we discussed today. And you do this by filing the I-130 petition for alien relative for family categories, I-129F for the fiancé visa, I-360 for either VAWA or SIJS, special immigrant juvenile status that we discussed. There's different forms that cover different family categories. I highly recommend speaking a lawyer. These are pretty complicated, and there's exceptions to exceptions in these. So we are here to help schedule your consultation today and start your pathway to a green card in the United States. Thank you.